So as you mentioned, today we'll be talking about latest developments in the implementation of the Digital Markets Act. Please allow me to share my screen. And Jürgen, it's funny that you said that it's been perhaps even a bit more than a year now. It has indeed been a bit more than a year, because in September last year, the European Commission adopted the first wave of designation decisions. So we count 1 year and 1 month of decisional practice in this area. And Jürgen, one thing that happened last week is I was speaking at the conference in Athens, and the chair asks me, you know what, you should be able to present both the case law on the DMA and the DSA, because with respect to the DMA, we've only seen a couple of decisions so far. And I was, no, we haven't. We have seen far more than a couple of decisions. And it's quite interesting to us working in that space to see how quickly the case law in the area has been evolving. And of course, there will be more decisions in the future. We will be able to learn more lessons from the decisional practice. Nevertheless, the decisions and the proceedings that we have seen so far can serve as a blueprint for future decisions. And therefore, we can draw some initial lessons from those decisions. Now, let me move on to the first slide of the presentation and explain a little bit how the Digital Markets Act works. Why? Because I understand that some people in the audience may not be very familiar with the regulation. First of all, the DMA is asymmetric regulation. What does this mean in practice? It means that it applies only to a specific set of companies that offer the so-called core platform services that reach a specific threshold. These core platform services that reach that threshold qualify as gateways for businesses to reach end users. Therefore, when we hear the argument notably put forward by gatekeepers saying the DMA will kill innovation, I'm not sure I necessarily agree with that, because we shouldn't forget that the DMA only applies to a specific set of services offered by a specific set of companies. So I think it's important to have this as a starting point in our discussion today. The second point that concerns the design of the DMA is that it's sector and service-specific regulation. You will see the DMA includes a rather broad definition of the digital sector. I believe this is the first time that a digital sector is defined in a legal instrument in EU law. And that sector is defined very broadly as a sector where products and services are offered by means or through information society services. So pretty much all digital services fall under the scope of the DMA in principle. However, the logic of the DMA is that it applies to a specific set of core platform services, which qualifies information society services. That means, in practice, when you go through the DMA, you will see that Article 2 lists those services, and we are talking about services that we use on a day-to-day basis. For example, search engines, app stores, e-commerce marketplaces, also known as online intermediation services. The scope is broad, but it's also not excessively broad to the effect that all digital services are covered. Now, one thing that is worth pointing out here with respect to the subject matter scope of the DMA is that, yes, it is in principle limited to these core platform services listed in Article 2, but to some extent, the DMA covers the entire offering of a gatekeeper. Let me give you an example. Article 5.2 of the DMA establishes the requirement that goes as follows. If you're a gatekeeper and you follow a core platform service, for example, a search engine for which you have been designated, you cannot combine data sourced from that search engine with data you source from other different services that you provide unless users grant their consent. So this is one example where the DMA scope covers services other than the core platform services listed in Article 2. Its scope in that regard is a bit broader than we might have initially thought. A third point is that the designation largely relies on a legal presumption. So we discussed presumptions in the context of the draft guidelines today. Let's discuss presumptions in the context of the DMA. According to that legal presumption, which is based on quantitative thresholds, a gatekeeper that has an annual EU turnover of 7.5 billion euro, reaches 45 million end users, has 10,000 yearly active business users, and has met all these thresholds for the past 3 years, qualifies as a gatekeeper, which means that once these thresholds are met, then the gatekeeper needs to notify the Commission that indeed those thresholds are met so that the Commission can adopt its designation decision. And that brings me to the fourth point that I wanted to make in relation to the design of the DMA, which is that the DMA implementation works in two separate stages. One of them is designation, to which I've already referred. The Commission adopts a designation decision, and as of the adoption of that designation decision, the gatekeeper has 6 months to comply with the obligations and prohibitions the DMA establishes. So it's not automatic, meaning the DMA gives some leeway, a few months, during which the gatekeeper can prepare its compliance plan. That compliance plan, and this is where other businesses come in, the implementation of the DMA, the compliance plan that gatekeepers must provide after those 6 months, and then after that on a yearly basis, and they set out how they intend to comply with the DMA, must be made publicly available. And you will see summaries of compliance plans have already been made publicly available on the Commission's website. And that feeds into the discussions and the arguments brought by other businesses, meaning third-party businesses that rely on gatekeepers if they want to raise a grievance, a complaint before the Commission, and if they want additional clarifications from the gatekeeper. Now, moving on to what the DMA actually does. So you will see in the table, we have many different obligations the DMA establishes. And of course, the purpose today is not to go through each and every one of those obligations. However, I think it's worth referring to how those obligations are categorized in the DMA. So we have the so-called Article 5 obligations. These are also known as self-executing obligations, meaning that there is no need to further specify how these obligations and prohibitions should actually apply in practice. At the outset, it should be very clear to the gatekeeper and all those involved in the implementation that there is a specific way in which gatekeepers should comply with these obligations. I will return to that point because in my view, Article 5 does not establish obligations that are necessarily straightforward. By contrast, Article 6 obligations and prohibitions are susceptible of being further specified. What does this mean in practice? This in practice means that the gatekeeper or the Commission on its own initiative can initiate the so-called process of regulatory dialogue with the gatekeeper, meaning they believe, either the gatekeeper or the Commission, that a specific obligation or prohibition is not straightforward, and therefore further discussions need to take place in order to decide how that specific gatekeeper can comply with the DMA. Now, clearly, as you can imagine, these proceedings are not concluded from one day to the next. You will find more details about the process in Article 8 of the DMA. And where I'm getting at is that this process cannot be launched with respect to each specific obligation, with respect to each specific gatekeeper, and with respect to each specific service. It would make the process unmanageable. However, we have seen recently the Commission use that specific Article 8 regulatory dialogue process with respect to Apple and the obligation to provide interoperability under Article 6.7. So this is something clearly that the Commission has started to use, and we may see more proceedings of the sort in the future. And then we have the third category of obligations in the DMA that concern how gatekeepers can comply with the DMA, broadly speaking. So we have an obligation to effectively comply with the DMA, which is closely linked to the so-called anti-circumvention obligation of the DMA, which I personally find particularly useful because many people would say that the DMA has been drafted in very narrow terms to prohibit a specific set of practices. And that is true to some extent. However, if we go through the anti-circumvention obligation of the DMA, we realize that this is a very carefully crafted clause that prevents gatekeepers from engaging in practices equivalent to the practices prohibited by the DMA. So essentially, it gives the Commission the opportunity to launch proceedings against gatekeepers, even if their practices do not fit squarely within one of the prohibitions in Articles 5 and 6. And then we have other sort of compliance-related obligations, for example, the obligation to inform about concentrations in which the gatekeeper may engage. So these are, broadly speaking, the three categories of obligations we have in the DMA. I would say that, as you can imagine, or as you can see from the table, the DMA covers a wide range of issues, App Store-related issues, for example, the anti-steering restrictions. Esther presented on that earlier today. We have then provisions related to search engines, for example, Article 6.5 on self-preferencing in ranking, and Article 6.11 on access to search data. And of course, we have other broader obligations that apply to pretty much every service that has been designated. Now, with respect to the distinction between self-executing obligations and obligations susceptible of being further specified, as I mentioned, in my view at least, Article 5 obligations are not that straightforward. And this has become very clear from the Commission's non-compliance proceedings launched against Meta in relation to Article 5.2. And I will get back to that in a little bit when I discuss the recent non-compliance proceedings launched by the Commission. Now, as I mentioned, the Commission has already started to develop a practice in this area, and it's very interesting to follow that practice closely. First of all, because as I mentioned, those decisions will serve as a blueprint for future designations, but also because we see that at this initial stage of the DMA, the very early stages, the Commission has made use of different tools it had at its disposal. So this is the table that the Commission provides that sets out which companies have been designated for what services. Clearly, as you can imagine, over the past year, this table has changed, meaning, for example, Booking.com was not in the first wave of designation decisions, but it was designated in 2024, so earlier this year. And we believe that, this table is a work in progress, meaning next year we will be having a discussion about a different table and about different sorts of issues that have arisen from designation decisions. But let me give you my take about what are some of the main issues or more controversial issues that have arisen from the first set of designation decisions we have seen. Now, I should start by saying that the designation decisions are clearly very specific to the company that has been designated, and also very specific to the services that have been designated. Therefore, if you want to find lessons that apply to all, I can tell you that one size does not fit all. Nevertheless, if we go through the first set of designation decisions, we will see there are a few issues that apply to more than one decision. Lesson number one concerns rebuttals. So the legal presumption that applies in the DMA, whereby a company qualifies as a gatekeeper, can be rebutted if the gatekeeper provides substantiated arguments that, even if that gatekeeper meets the quantitative threshold, they are not a gateway for businesses to reach end users. Now, I must say, when I was working on the DMA before the DMA was actually adopted, I found during the legislative process how a specific recital in the DMA was being formed, and I'm referring to recital 23. What does this recital 23 tell us? It tells us that if a gatekeeper wants to rebut the presumption that it is a gatekeeper because it meets the quantitative threshold, the arguments it can put forward can only relate to the quantitative criteria set by the DMA. Now, as you can imagine, or let me give you an example to make it a bit more clear, let's assume that a gatekeeper has a service and that service reaches slightly more than 45 million monthly active end users. It can go to the Commission and say, well, listen, I exceed the threshold, but only by a little bit, and therefore I should not qualify as a gatekeeper. As you can imagine, this forces both the gatekeepers and the Commission to engage in a circular discussion around those quantitative arguments. So my take on recital 23 from the very beginning was that recitals, according to a very long line of case law of the courts, are not legally binding. And since the relevant provision of the DMA, Article 35, only refers to the circumstances in which the gatekeeper operates and the circumstances in which that service is offered, then everything goes. All arguments, including qualitative arguments, can be put forward by a gatekeeper. And this is indeed what happened in practice. And if we go through rebuttal decisions and rebuttal arguments that the Commission has accepted, we will see that the Commission has indeed been open to qualitative arguments. When I say qualitative arguments, I suggest that you have a look at Article 3.8 of the DMA, because these are exactly the arguments I'm referring to. For example, low switching costs, no lock-in effects, network effects, data-driven advantages, all these sorts of parameters. So, for example, with respect to Samsung Internet Browser, because believe it or not, Samsung Internet Browser did meet the quantitative thresholds of the DMA, Samsung put forward this sort of qualitative parameters. However, there is a question, there is a catch, and this is something that I believe the Commission should clarify in the future. We go through the decisions and we see that the gatekeeper indeed puts forward qualitative arguments, the Commission accepts them, and then you find towards the end of the analysis a reference by the Commission to the fact that this designation decision is primarily based on the quantitative criteria set by the DMA, and it refers to recital 23. Now, I don't think this is the case, but I was thinking when I was reading the decision that the Commission was trying to find a link to recital 23. The main point here is that rebuttal arguments that have been raised by the gatekeepers have been accepted, even if they do not relate to the quantitative criteria. The second lesson that one can learn from the designation decisions that have been adopted so far is whether the core platform service that we're talking about is a business-to-consumer service or a consumer-to-consumer service. And as I have described to you already what the purpose of the DMA is, which is to capture gatekeepers, meaning companies that act as gateways for businesses to reach end users, we are primarily targeting business-to-consumer services, right? But Facebook, now Meta, and TikTok raised arguments in relation to whether their services are B2C or C2C. So essentially, they claim that Marketplace qualifies as a consumer-to-consumer service, and that TikTok for Business is a business-to-business service. And this is how they try to convince the Commission that they do not meet the quantitative criteria set by the DMA. And there the Commission, correctly in my view, said in the case of the Marketplace that even if Meta has stripped down the tools that do not enable businesses to market their products or to use different ways in which they can market their products through Facebook, businesses can still sell products even through their Facebook account on Facebook. And therefore, this threshold, this number of business users that Facebook has becomes bigger, it exceeds the thresholds, we do not accept the argument. With respect to TikTok for Business, the Commission raised arguments on the role of natural persons, the so-called content creators or influencers, that can also qualify as business users. And again, I found that part of the analysis very interesting. And on a personal note, I think it's fully aligned with consumer protection regulation and how the term trader has been defined in a long line of case law, in EU law, in a national law, but also in EU consumer protection regulations, for example, the Unfair Commercial Practices Directive. So this was the right way to go. With respect to the third point that I wanted to raise in relation to designation decisions, one interesting point has arisen from Apple's action for annulment against the designation decision the Commission adopted. So I'm sure that some people in the physical room and the virtual room have iPhones. They also have iPads and perhaps even a MacBook. What Apple is trying to say is that the App Store it offers is different by reference to the device and the operating system on which it runs. That in practice means, according to Apple, that Apple should have been designated only for the Apple App Store on iOS, and that it should not have been designated for the Apple Store that runs on the other devices, including MacBook, iPad, and so on. Now, in my view, when we go through the Commission's designation decision, Apple did not raise the right arguments in this specific case, because what it is trying to do is it tries to engage in a market definition exercise. It tries to say that the App Store and the device are different by means of the product characteristics, their intended use. And these are arguments, of course, that are reminiscent of how the Commission defines relevant markets in the sphere of antitrust law. But the DMA explicitly says that the designation process is irrelevant to market definition, and in fact, it discourages gatekeepers from raising market definition arguments. The other argument that I would raise, and I think the Commission has also raised, concerns the principle of technology neutrality. And if we go through the definition of App Store in the DMA, we see that this definition, this legal definition, is not linked at all to any devices or operating systems. So clearly, I cannot predict what the court might say because the case is still pending before the court. But I think there is a good chance that the Commission will win the case. Now, moving on to recent proceedings that the Commission has launched. And I think it's worth taking a step back and discussing how or the context in which the Commission launched its non-compliance proceedings. As I mentioned at the beginning of my presentation, gatekeepers are required to prepare compliance plans, which are made publicly available. The Commission, in the context of the best practices that it intends to follow in the implementation of the DMA, invited gatekeepers to present these compliance plans to third parties, including, of course, business users. And after a few days, only a few days after those workshops took place, the Commission launched that it would be announced that it would be launching non-compliance proceedings against a specific set of gatekeepers with respect to specific aspects of their compliance plans. So that, in principle, means that the Commission is determined to make it work. But of course, we will see to what extent there will be appeals against these non-compliance decisions, if there are non-compliance decisions adopted, because of course we have the commitments route in the DMA, and how the court will react to all the arguments that will be raised. But suffice it to say for now that these non-compliance proceedings concern a wide range of issues. So, you will see that Apple clearly has most issues that it's currently dealing with in the context of non-compliance proceedings. And as I tell my students, because I always give them that example, it's easy to understand why the Commission wanted to specify a lot of aspects in relation to Apple's compliance plans and how it disagrees with Apple on a few points, because Apple's compliance report is 12 pages long, as opposed to Google's and Meta's and Microsoft's, which are much lengthier and much more detailed. So clearly, the status of all these proceedings is still pending, but, and this is in stark contrast with antitrust law, the Commission has an obligation to complete these proceedings by March next year. So these proceedings were launched in March 2024. These need to be completed in a few months. So we will see what the outcome of those decisions is and how we can comment on them in terms of what was the approach followed by the Commission and what was the approach followed by gatekeepers. One thing that I wanted to mention with respect to the non-compliance proceedings is that, and it's very interesting to me, the Commission, in its decision to initiate non-compliance proceedings, relies on the so-called anti-circumvention obligation. Let me give you one example. The Commission launched non-compliance proceedings against Google in relation to how it ranks third-party products and services compared to its own services. So the Commission was not satisfied with what the Commission with what Google put in paper and decided to launch the proceedings. And in that decision, the Commission also refers to the anti-circumvention obligation of the DMA, which specifically says that gatekeepers cannot use behavioral techniques or the design of the user interface to nudge end users into using their own services. And in my view, again, I cannot predict the future, but my impression is that the Commission's decision, if we see an infringement decision in the case, because we may see a commitments decision, is that it will rely very much on those aspects of the anti-circumvention obligation. Another point concerns the Meta proceedings, and this is, again, a very interesting case that we have been following closely. With respect to Article 5.2, you may remember that Meta announced at some point that it will be launching, in order to comply with the DMA, the so-called pay or consent model. You either pay a subscription or you consent, and then you can use Meta properties for free. Meta relied on the Meta Platform's judgment because the court in that judgment says that a company can charge a fee in order to enable users to use the service, but that could also enable the gatekeeper in the case at hand to extract data. So Meta decided to go for a binary solution, pay or consent. But when we go through the Commission's press release and the decision to initiate non-compliance proceedings, we realize that the Commission is concerned about the fact that the pay or consent model may actually not be giving a choice to end users, and therefore something more may be needed. So we will see whether Meta will need to come up with 3 or 4 or 5 different solutions to satisfy the Commission. The key point here is the issue of choice. How do we make sure that end users have choice when they decide to use Meta properties? Now, I've already referred to some of my main conclusions with respect to the non-compliance proceedings. I think that summing up, we do not have any specific lessons to learn other than the issues around the anti-circumvention obligation, to which I've referred, and the breadth of issues that non-compliance proceedings can concern, even when they regard one specific gatekeeper. Of course, we will find out soon, because as I mentioned, the Commission is bound to adopt its decisions by March 2025. And with respect to the specification proceedings, I mentioned that this is a type of proceedings that was launched with respect to Apple so far in relation to its Article 6.7 obligation on interoperability. However, it will be interesting to see how granular technical these decisions will be, how willing gatekeepers are willing to cooperate with the Commission, and whether these solutions that will be proposed in the context of those proceedings will satisfy business users. Now, if I have one more minute, I wanted to make some broader remarks that allow me to take a step back and consider DMA-related issues, but not necessarily specific to the DMA. One of them concerns the breadth, the wide range of rules that have been adopted in recent years. And I am referring first and foremost to EU rules, for example, the DSA, the Data Act, the Data Governance Act, the AI Act, the Media Freedom Act. So clearly, we no longer discuss the interplay between the DMA and competition rules. The issues go far beyond that. It's the DMA, it's the interplay between the DMA and all these different rules that apply to platforms that could potentially qualify as gatekeepers. So one of the questions that will arise in the near future, in my view, is how do we make sure that all these rules work in tandem with one another rather than contradict one another? And that's a very important point to remember and consider, because as you know, the court is the ultimate arbiter of tensions between different rules, and we don't want different instruments or provisions thereof to be annulled by the court just because they contradict one another. We want the EU acquis in this area to work. The other point concerns rules that have been adopted in other jurisdictions. I'm based in London, and you may have seen that the UK has recently adopted the so-called DMCC Act. So one question, and it's not a philosophical question, it's a question with major practical implications, is whether A, the DMA will produce any so-called Brussels effects, and B, how the DMCC Act, the DMA, and all these other instruments that are currently being considered in different jurisdictions will work with one another. And the final point that I wanted to make concerns how future-proof the DMA and other rules are. And this is an interesting lesson that we can draw from these recent proceedings and designation decisions. Now, as you know, when the DMA was adopted, nobody was talking about ChatGPT, generative AI. So a discussion at the moment that takes place in DMA circles is whether the DMA applies to generative AI. To which my answer is, this is not clear. For example, when a generative AI tool falls or is an integral part, an integrated part of a search engine that has been designated, then it clearly falls in scope to the extent that the search engine has been designated. But whether a bot in and of itself would qualify as one of the core platform services that fall under the scope of the DMA at the moment, this is not so clear in my view. And the same applies to the discussion around the DSA, whether generative AI qualifies as a hosting service provider and so on. What I'm trying to say is that it's very good to have specific rules and specific legal definitions that increase legal certainty. However, moving forward, we need to think of ways as to how we can future-proof these instruments. And I think this is where the review clause of the DMA comes in, to make sure that these instruments are here to stay and I can actually address practices arising from tools that we didn't have in mind when those rules were initially designed. Thank you for your attention. I will leave it to that, and I'm happy to answer any questions you might have.